Mr. Fayette, you got the memo to be here today. That's good. I see Mr. Russo did. Looks like I left somehow Mr. Day out of the loop of being here today for this calendar call. And I had at first said 1:30, and then Ms. Armpriester said she wasn't available at 1:30 because of 24. So kind of all got all messed up, but we somehow got everybody here anyways, which is great. There we go. There we go. I see Mr. Carr. You were a little you're a little out of the screen there. How are you? You're muted.
I'm so sorry. I'm so sorry.
Gotcha. Sir, named Jose. Sir, could you mute your microphone, please, sir?
Your Honor, that is my client.
Oh, okay. So, Ms. Armpriester, let's address your case. And for the record, everybody, just so everyone knows, it is likely that I will have the trial tomorrow in the event Judge Foster's doesn't go. So it would have to be a one-day trial, though. So if anybody thinks they're ready to go, but it will take longer than a day, we will not be able to do it tomorrow. So that's kind of the information that I'll need moving forward today with everybody, okay? All right, Ms. Armpriester, your client is Mr. Mario Cabaracas, 19MM 2199.
Yes, Your Honor. We're here today for last call. I do believe we'll need more than a day. So I'm not sure that we are the appropriate trial to go this cycle. What we're docketed.
I'll defer to Ms. Armpriester, Your Honor, if she believes we need more than a day. If her state does not, but Ms. Armpriester believes we do. I don't know who defense plans on calling as a witness aside from the defendant, but.
Ms. Armpriester, why do you think that this case would take longer than a day? Are there a lot of witnesses or complexities that would cause it to go longer than a day?
It's complex, Judge, and based on what I've seen with the other COVID trials and between jury selection and the actual trial, I think we'll need more than the one day that we have allotted for tomorrow.
Do you all want to move this to a pretrial? Or do you want to move it to next week? Because I am going to have trials next week.
Doesn't matter to me, Judge. We're also here on my motion to depose the victim.
Okay, all right. And I think we should probably address that once we have everybody else taken care of, because that motion may take some time.
Okay.
So let's hold off on doing anything with this case yet, because if I grant the motion to take the deposition, it will not be ready for trial next week. And I do want to hear argument on that. Mr. Fayette, where do we stand on your cases, sir? Okay, thought I had two cases with you. Is there only one? All right, we'll take the plea at the end of the docket. And the other case that you have, sir? You remain ready. All right, so the other case that we have is.
That will not be a one-day trial. The state filed a motion today to eliminate. The state asked the court to hear next Monday at calendar call. There will be a number of witnesses that the state will be disputing.
The state is doing their job. That should have been filed a year ago.
Your Honor, defense is announced ready. The state is taking the posture of ready. The state is entitled to file pre-trial motions to be heard by this court as it relates to evidence to be admitted at trial. The state is trying to save time at trial. Should this go, I'm really not quite sure what defense's objection is to this. He announced ready.
All right, let's address that in a minute as well. I want to see who else. Mr. Carr, are you guys ready on your case, sir? On Mr. Guerrero, 20 CT 1151?
The defense is ready, Your Honor. Can I make a point?
Yes, sir.
There's no wheel witness in this case. The state has listed a wheel witness, but they don't have them under subpoena, and there's no way for them to have a trial.
Mr. Rabb?
State's ready.
Will this be a day? Because I'll hear it tomorrow.
Likely a day, Your Honor. This was scheduled for the second.
Oh. And why is it on for today if this is scheduled for the second week?
I think we moved all of your cases, Your Honor, to this week.
I thought we had.
Whatever reason.
I thought we had everything, like them set 6 today, which were for this week, and then the others are set for next Monday at 9 a.m.
That was my understanding, Your Honor.
Yeah.
I looked on Tuesdays, and there's 6 cases set tomorrow, and 3 cases on today's docket.
Those 3 were supposed to be today, and I actually told Jen this morning, I said, we have to make sure that all 6 are on for today, and I guess they didn't end up on this, but they're set for tomorrow, and I wanted to talk about them today to figure out which one was actually going to go tomorrow.
And there were cases, I believe, that Mr. One is here to represent that I called, which I will review for this week that are not on today's calendar.
but they're on tomorrow's docket for tomorrow. I don't know what happened, but yeah, what I wanted to do today was figure out what was going tomorrow. In the event that Judge Foster's case doesn't go, I wanted to have one teed up to go tomorrow. One that'll take a day. So that's where we're kind of at right now.
Yes,
So you're saying that Mr. Carr's case is actually set for next week.
it is.
All right, Mr. Carr, I apologize. We slotted these all, the ones that were going next week were supposed to be calendar call at 9 a.m. next Monday. So are you available at 9 a.m. next Monday? We can address your case then.
I'll be glad to be here, Your Honor. I would point out that they're still not going to have the wheel witness.
They may not, and that might be an easy win for you.
Well,
Because if you put them behind the wheel of the car, I don't know how you put the case.
I don't have, my only concern here, I know we're going to win, but my only concern is we don't inconvenience the citizens of Collier County by putting this on a trial docket and having a panel of wonderful citizens waiting to have the state say, oh, we don't have the wheel witness. And that's just rude, Your Honor.
I agree. I'll have a backup. Yes, sir. I'm putting it on at 9 a.m., but it may be one of the cases that goes to trial. And if that information is accurate, we want to make sure we have a backup, because we do not want to have people that are coming in for jury trials. Okay. We have some older cases, Mr. Carr, so it may be, in fact, that yours may not be the oldest on the docket, but we can explore that next week. So 9 a.m. on Monday for calendar call.
Let me note that the missing witness that they need is named Valdes. He's the only one they have that can put him behind the wheel, and he's not available. He's not around. Mr. Valdez.
He's disappeared.
He's-
You never know. I wouldn't say so, but it sounds like Mr. Valdez is gone to greener pastures somewhere or something like that. I don't know.
Somewhere, Your Honor. We're not sure where.
And Mr. Rabb has assured the court that he is going to investigate it thoroughly and we'll have an answer by next month.
All we can ask of the state is they do their own professional job and discover they don't have a witness, so we don't waste the jury's time, Your Honor.
Sounds good. All right, thank you.
Thank you, Your Honor.
Okay, let's get back with, Mr. Fayette, do you need to be somewhere? Okay, I'm going to take Ms. Armpriest's motion because she has 24s. All right, let's talk about this deposition.
Judge, I brought this motion in good faith last week. Ms. McAllister gave me a hearing date of March 30th for it. I did bring it to your attention at our trial call, just that it didn't seem right to just throw in a motion to continue, given that I was given this hearing date when we were set for trial this week. Your Honor, I was given an offer this morning for the first time on this case, and I know that there's been some back and forth on that the victim wanted a trial. However, what was told to me was that an offer was forthcoming once the victim had signed off on it. I did get that this morning, but in preparing for trial, I did file this motion because I do feel in good faith that my client is prejudiced by my not being permitted to take a deposition of the victim. Florida Rule of Criminal Procedure 3.220 subsection H1D states that the court should consider the consequence to the defendant, the complexity of the issues involved, the complexity of the witness testimony, and any other opportunity available to the defendant to discover the information sought by the deposition. I do understand that a well-written, meaning it's legible, it's easy to understand, it's written in English statement was provided by Ms. De Silva. However, it lends itself to complexity of issues and complexity of witness testimony, all that lead to great consequence to my client, who has 0 priors. I don't believe he even has an arrest. And this could really, really ruin his life, not just his lack of criminal record, but also his professional ability to earn a living for his family, the way that this case could go. I am asking that the court allow me to depose the victim, Ms. De Silva. I have tried to call her twice. I understand that this isn't comfortable for her. My intent is not to embarrass her, harass her, or any of that. I'm just trying to extrapolate on her sworn statement so that I'm doing my due diligence in zealously advocating for Mr. Murillo Cabracas. And I do believe that he is prejudiced that in his preparation for trial, we would not be allowed to depose this particular witness. Thank you, Judge.
Thank you.
Yes, Your Honor, the suit agrees with the relevant citation that.
I can't hear him, Your Honor.
Can you come up? She can't hear you. Yeah. One, two, two, maybe that'll help.
Can you hear me now, Ms. Armpriester?
A little bit better.
He's right at the bench, so I can't do any better than that.
Thank you.
So, we agree with the relevant section of criminal procedure that Ms. Armpriester stated. We disagree that these issues are complex in any way. This is a battery that occurred at a massage parlor. You have a copy of the sworn statement given by the defendant at the time. Not only is it in English, not only is it legible, it is extremely detailed as to the facts that occurred, which is ultimately the reason for the deposition. So Armpriester has not been in any way, or the client been in any way prejudiced by not having a plea offer or not being able to gain any additional information than what is in the sworn statement, which are the facts of the battery, which the victim intends to testify to. The state would object to deposing the victim in this case. I believe all the information needed is contained in this report, Your Honor, and you would like to.
I would like to see it. Thank you.
Thank you. May I return to?
Yes, you may. Thank you.
And Judge, I do agree with what Mr. Rabb is stating, that it is legible, it's in English, and it's detailed. But because of the fact that it is so detailed and there's no chance for follow-up, it does lend itself to a complexity of issues.
Respectfully, Ms. Armpriester, I disagree. The motion to take depositions is denied. Case will remain as set for calendar call 9 a.m. next month.
Judge, it was set for tomorrow. So
Oh, I
are
thought this was,
we picking it to next week?
because you said it can't go for one day. If it was going for one day, I'd set it for tomorrow as backup to Judge Foster's, but you said it'll take more than a day.
I am anticipating more than a day, Judge. I like Judge or Mr. Carr was saying, I just don't want to get us to the point to where then we lose that day, when I would feel terrible if that happened.
Right. So that's why I'm going to move this to next week for calendar call at 9 a.m. because we're not going to be able to do it in a day. So it makes sense to just see what happens with the ones that are set for next week.
And Your Honor, I understand you're denying my motion.
Yes.
I don't believe I need to submit an order. Is there any way that the court, I know you can't force it, but can the state attempt to have a conversation between me, the state, and the victim? Because she's not returned my call.
She may not return your call. I mean, we can't make her return your call, Ms. Armpriester. You can have Mr. Rabb ask her to return your call, but she.
Which is what I'm asking, just that to get some assistance with that so that I can do my due diligence and not be prejudiced for trial by this victim not wanting to, or it being able to meet her and confer.
Certainly ask Your Honor.
He says you will definitely ask her.
Thank you.
All right. Thank you. We'll see you again next Monday.
Next Monday at 9 a.m. for calendar call.
9, yes.
Jose, I'll be in touch. May be excused.
Yes, ma'am. Thank you.
Thank you.
All right. So let's now talk about Mr. Fayette's case. It has the motion that's been filed, and I haven't had a chance to look at it and refresh my recollection again as to which case that was. Was Mr. Cisneros? 19 CT 1906. Is that the case we're talking about?
Yes, Your Honor.
Yes. 19 CT.
The issue that Mr. Fayette brought up last week, Your Honor, is that the state does not have a real witness, and that is true. However,
Similar witness or issue just came up 5 minutes ago.
However, Your Honor, Second Circuit case law and First Court case law are very clear on this matter that in cases involving injury or manslaughter as they relate to evil, the state has no obligation to show the identity of the defendant as the driver to prove corpus. The issue here is whether corpus can be proven for them to get in admissions made by the defendant. The state would like the court to make a decision on the admissibility of those admissions and therefore whether or not the state has properly met corpus at a pretrial hearing. So we do not raise this court for a valid purpose.
So is this going to be the hearing right now, or we have got this issue set for here?
No, Your Honor, the state is requesting that this be heard next Monday after calendar call. Quite frankly, Your Honor, there will be possibly 5 state witnesses that we need to bring for this to establish corpus. But again, the state does believe that we are able to establish corpus based on the relevant case law, both out of our circuit and the court Supreme Court, and is asking the court to make a determination as to the admissibility of those admissions.
Well, I haven't seen any of this case law or even had this issue come up before, so I don't know what my decision would be on that because
It is cited in
the motion is definitely not of record that I can see. So
and it's an instruction for J.A. copy.
that would be great. Mr. Fayette?
They're asking you to make it, they're asking you to listen to testimony and make a ruling on things, whether or not they're going to be admissible at trial. Motions in limine make sense, and they got a motion in limine because we want to make sure things don't get out in front of the jury that aren't supposed to. They're asking you to make a legal ruling as to they've met corpus and they can bring in statements.
That's correct, Your Honor. The evidence that the state would like to admit at trial is dependent on corpus being sufficient. So in an effort to not waste, again, this court's time, counsel's time, a valuable jury's time, the state is requesting that that determination be made ahead of time. There was one of the cases cited in the state's motion is LIABLE. In that case, it was a defense motion to suppress that was ultimately determined in that issue. So there is precedent for a pretrial motion as it relates to the admissibility of such admissions and, for that matter, corpus.
All right. Well, I'd like to hear this before Monday. Are you gentlemen available, or could you come up with a time to be available maybe on Wednesday? I know I'm covering for Judge McPhee in the morning on Wednesday morning, and because this is my jury trial week, backup, I don't have anything else, and I could set it. I just, Monday seems like it's too late, especially if we're going to set this case for trial and it's going to go next week.
The state's only concern is that one of the state's witnesses, who's an FHG officer, has been reassigned to West Palm Beach. The state does make time to subpoena its witnesses.
If we're going to have witnesses, couldn't they appear over Zoom? It's okay with me. I don't even know why we need witnesses, but then again, I haven't seen your motion yet.
I assume they're available.
Okay. So I need to look at the motion and think about it. But my preference would be to hear it before Monday because, we're going right into a trial week.
And again, Judge,
And this case is almost 2 years old.
how we got here is because I was curious enough to let the state know what their problems were. Instead of using that and figuring out what they can do for it, they've taken it, they've turned it on me, and now they're trying to ram in through some method of a three-word supposed admission the day it's set for trial. Noon it was filed today, or I got a copy today, I don't even think it's filed yet. And they're trying to jam this down there. We're talking about timeliness and doing your work ahead of time. I understand what's out there, but it's going to be a real problem within your courtroom because I can tell you, no one is going to give up the state anything. You said you like people to work together. There is no working together. They take and twist everything you have and use it against you. And now I'm supposed to drop everything. Obviously, I'll do whatever the court said, but I'm supposed to drop everything except for the week to be able to address his 3-page motion.
Yeah, I'm not going to ask you to do that. I'm not going to ask you to do that. I'm not going to ask you to do that, Mr. Fayette.
Your Honor, the point is that there is a misconception as to whether or not there was an issue with this case. And as the state is going to present at its hearing, there is not, and that is due to relevant case law on this matter.
Okay.
Again, all the state would request, Your Honor, is that sufficient time be made to allow the state to ensure that its witnesses can be available.
Why don't you guys talk to each other and see if you can come up with a day and time, and I could probably hear it almost any day this week except for Thursday.
Yes, Your Honor.
So I'll come up with some other time for you guys. If you guys can come up with a time. If you say, the only time we have to do it is Monday, we'll do it Monday. But it just seems like the day before trial with everything that's going to be going on next week, it just didn't seem like the right time to do it. But if it's right, if it's what we've got, it's what we got. So and I'll take a look at this motion once I get it, and I'll look at whatever research you both want to provide to me and have that all done before, the hearing on the issues. All right?
Since they want to talk about the time limit,
Okay.
I do think, and again, I'll give it to the discretion, but We're going to look at the timeliness of this and force them to do the work prior to us getting here, not putting us all in this position, which they didn't do.
Well, I've had a lot of this from a lot of people this just in the last week, and I think a lot of it has had to do with the fact that we haven't had a jury trial in a year, and all of a sudden I have 2 weeks that I've got scheduled for jury trials, and I'm not the only judge this is happening to. I've already talked to almost everybody else who's had a jury trial week, and the same kind of stuff. There's motions being filed that should have been filed a year ago. It's causing everybody to scramble. A lot of people to scramble, and I realize some people aren't, some people are. I just have to realize, at least for me, that a lot of this is happening because we haven't been able to have jury trials. And so I'm not going to pick on anybody right now about that, because we are going into our first few weeks. But I feel like this is just the beginning. We're going to start opening up, and we already are talking about having 2 judges have 2 weeks of jury trials, which leads to 3, which leads to, so everybody who's been kind of sitting on their cases is going to have that blank moment that they have to get their stuff filed. Because right now, I think we're all going to be giving everybody a little bit of a pass because this is what's happening. But as we start rolling into more and more jury trials, the hammer's going to come down on this stuff. No, you are well within your rights, sir, but it's just like there's a lot of difficulties with this particular case. And I don't know if they can. I would love it if they could be resolved between you two. I don't know that they can. I'm going to have to hear this motion, and we'll have to go from there. Okay. So it'll remain set on Monday unless you guys could come up with a time that works with my schedule before Monday. I'd be more than happy to hear it then. All right. Okay. I think we got a plan. And Mr. Fate, you have your plea. Let me just take Mr. Gorman's cases. Mr. Gorman, do you have a case that's ready to go to trial?
Yeah, Judge, you got 2.
Yes.
Only problem
Uh-oh.
is-
Why did I did the yes first before.
No, it might not be a problem. We're also set on with Judge Foster as one of the ones to potentially go tomorrow. So if Judge Foster doesn't end up going, then we could go.
Okay.
Otherwise, we
Are
could-
you arguing a motion in front of him at 1:30? Because that's the case that's queued up to go tomorrow.
No, Judge, that's not. We're one of like 3 or 4 other ones that are back up.
Yeah. Because I actually talked to Judge Foster before this, and he indicated to me that if the case that's set for tomorrow doesn't end up going, then he has another one that's starting Wednesday for 3 days. So I don't know if
That's
that,
not our one.
so it doesn't sound likely that you're gonna go.
We're not high in the order, but we're set for tomorrow to go on in the lineup.
Yeah.
That's a one-day case in front of Judge Foster. I don't know if you want to take us or not, but if we don't go in front of Foster, we are prepared to go tomorrow
Okay.
on either one of these cases, Forrest or Mr. Moran. But then, which I do think are gonna be one-day trials, Wednesday and Thursday, Mr. Day has trials in Lee County that are already set, and then we could do up by trial Friday.
Okay. Well, I could set one of them for tomorrow. I've been told by Judge Foster, however, it cannot go into the second day, which means if it goes longer tomorrow, we're gonna stick through it until the bitter end.
That's fine. To give you an example, Forrest is spit, it's a bad record, so I can't imagine that would take too long.
Okay.
And the other one, I don't, today's pretty quick, it's pretty serious, so I think.
I actually have seen, let's see, so we've got Forrest is one, and then the other one is Mr. Marine. And let's see, they're both about the same age too.
And Your Honor, out of convenience to the witnesses, the state would probably request that Forrest be the one set tomorrow if that's what's going to
We are all right as long as we don't go Foster.
I will know this afternoon from Judge Foster, and I'll let you gentlemen know. Let's set Forrest for tomorrow. And do we want to put the Marine case at 9 a.m. the following Monday, Mr. Rabb? Okay, that way we can figure out which ones are going to go next week. Because Judge Foster didn't indicate to me that the other case that's set this week would take up the whole rest of the week. So
Yeah, I know there's a lot set Foster, so Judge R's not high on priority. He's out of custody.
yeah.
But we're still in the lineup.
All right, so we're lined up on this for tomorrow, and I'll let you guys know probably by like 4 o'clock is what Judge Foster indicated to me, whether his was gonna go tomorrow or not. All right? Okay, we got a plan. Sounds good. Thank you. Oh, okay, wonderful. I'll look at it today when I get back. All right, we are ready for our plea for Mr. Wright, 19 CT 1846. Thank you for waiting patiently, Mr. Wright. I appreciate it. Do we have a plea form for him? Has he gotten that done? Okay, wonderful.
Mr. Wright, present for the court, since he's very on the speech of contest, there are 2 counts.
Okay.
That's ready, I agree with the term.
2 counts, okay.
Count 1, adjudication, $500 fine, 10 days jail to be served on weekend court, a weekend lockdown, court cost prosecution. Talk about concurrent probation, so count 2 holds probation. I'm not sure what the term they want on that. I'm guessing 12 months also. So on count 2, it's a DUI second outside of 5. 2, adjudication, 12 months of probation, 12 months loss of license, substance abuse evaluation, follow recommendations, random testing, $1,000 fine, DUI school level 2, 10-day vehicle impound, victim impact panel.
Wait a minute, how long was the impound? I'm sorry, you're going too fast.
10 days, sorry.
Thank you, that's okay. Yep,
Victim impact panel, 1-year ignition interlock, and
okay. And on the first count, it was also 1-year probation, is that right? Okay. And I think I got it all. Need to get him sworn in.
Raise your right hand.
I solemnly swear or affirm that testimony you shall bear shall be the truth, the whole truth, and nothing but the truth.
So would you please state your full name and date of birth for the record?
David Ray Wright,
And what's your date of birth?
3/2/50.
Thank you. Mr. Rabb, can you tell the court what the maximum penalties are for each of these 2 charges, please, on the record?
For refusal, it is a first degree misdemeanor, punishable by up to a year in jail.
Okay,
For the second DUI, it would be 270 days.
thank you. Sir, do you understand the maximum penalties that you could face on each of these charges? And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? Have you read and signed a plea form? Do you understand all the rights you'll be giving up by entering into this plea? Are you entering into this plea because you believe it's in your best interest? Has anybody threatened you or made any promises to you to cause you to enter into this plea? And sir, you've been represented by Mr. Fayette. Are you satisfied with his advice? Do you have any questions for him or for me before you continue with your plea? Are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to enter into this plea? Do you suffer from any mental illnesses?
No.
Do you understand that if you're not a United States citizen, that this plea would likely be used against you in a deportation proceeding? And sir, do you understand that a DUI is an enhanceable crime, which means that there are circumstances where it could be charged as a felony? And that it also can be used as a basis for the Department of Motor Vehicles to suspend your driving privileges. Any other questions I need to ask him, Mr. Rabb? Mr. Fayette, you stipulate to a factual basis and venue for the purpose of the plea?
yes, sir.
Okay, so sir, I will accept your plea, find that there is venue and a factual basis, and also that your plea was freely, voluntarily, knowingly, and intelligently made. To the charge count 1, refusal to submit to DUI testing after previous suspension, the court will adjudicate you guilty. There will be a $500 fine plus the court cost of prosecution. 12 months of supervised probation. Special condition is that you'll spend 10 days in the Collier County Jail, which may be done on weekend work or weekend lockdown or straight if you choose. It'll also be concurrent with count 2. Count 2 DUI second offense. There'll be an adjudication of guilt. 12 months of supervised probation, 12-month loss of license, substance abuse evaluation, follow all recommendations, random urinalysis or breathalyzer upon request and at your own expense. $1,000 fine plus court cost of prosecution, DUI school phase 2, 10-day vehicle impound, victim impact panel, 1-year vehicle ignition interlock, no alcohol during your probation, no alcohol in your residence, and no visiting any bars, pubs, taverns, lounges, package stores, or places where alcohol is primarily served or sold. Did I get it all, folks? I think so. Yes. Okay. Good luck to you, sir. Thank you. Thanks for coming in today and waiting.
He has the time in, and I guess because we can work, we don't need to manage today. Sure.
Okay. He already has some time in. I didn't say it for the record, credit for all time served. Thank you. Thank you. All right. All right. I think that looks good. Yep. Thank you.